Okay, some introductory remarks. We decided that we will not go into the legal details because that would be going too far, and you as the audience would not really benefit from it when we start to discuss what a money service business is in the US as compared to a payment service provider in the EU. We want to give you an overview of the regulatory landscape in the US and Europe and work out some of the major points that you should be aware of when you're doing your Bitcoin businesses. And the entire discussion may be a little bit frustrating for you because we cannot give you clear-cut results because the regulatory landscape is moving at the moment. So at the end, we will try to have a question and answer session so you can come up with specific questions, and we come up with not so specific answers. As the regulatory situation is advanced in the US as compared to the EU, I would like to ask Patrick, as General Counsel of the Bitcoin Foundation, to give us a summary of the things that have happened in the US and where you stand.
Just a quick summary?
Quick summary.
Yeah. Start at the beginning of time. Start at the beginning of time? Okay, yeah. So probably the most important thing that happened is FinCEN issued interpretive guidance around decentralized convertible virtual currency. And that laid out an initial framework for how you should think about running a Bitcoin exchange. And it set a standard that allowed venture capitalists and other investors to come in the space and feel secure that this is a legitimate currency and that these are legitimate business opportunities. There's some challenges with the guidance and how it was actually issued, and there's some tweaks to be made still with that, but generally that was a positive sign, and it really moved things in the right direction, and you could see it. I mean, the volume, the transaction volume was picking up, adoption picked up, the price moved, everything went up after that. And that was that was probably a watershed moment for the industry. Since then, there have been some other things. The CFTC has made some noise about, the Commodities Future Trading Commission has made some noise about coming into the space, and some others have as well, and there's some noise about the FTC protecting consumers. And then, most recently, California and some other states have decided to take, the consumer protection issues up. And so, maybe we can consider it the next watershed moment when the Bitcoin Foundation received their non-cease and desist letter from the California Department of Financial Institutions. We've actually just issued our response back. Hope to make that public very soon so everybody can read how that correspondence is going. What we laid out for them was, we don't think that, as a foundation, where these laws apply to us. We kind of laid out what we believe that the law was and should be, and we asked them for a letter opinion on whether selling Bitcoins directly to consumers constitutes money transmission and needs a license. So they don't have to respond to that, but it puts the issue out there for them. And you can take that however you like.
Okay, thanks, Daniel. Anything from the other panelists to add to that summary?
Well, I think Patrick's in the thick of it now. But one problem that we have in the States is that although the Department of Treasury came out and sort of clarified things, now we're at a state-by-state level. And we've seen the first state, California, be somewhat aggressive, and there are a few other states who will also be aggressive. So as far as the state-by-state analysis, time will tell, and I expect we'll see future confusion as we've seen so far.
Mm-hmm. And I actually, shortly following the Bitcoin San Jose conference, which I think was another watershed moment in some ways, because you could see this critical mass forming for the first time. This wasn't kind of this fringe hacker technologist movement. It became something that was actually viable as a business and something that important stakeholders in our country and globally could really buy into. And so, one, as Patrick mentioned, one of the positives of the FinCEN, few as they are, of the guidance was that they, in fact, acknowledged and legitimized Bitcoin as a medium of exchange. And so that was actually, that helped kind of propel it from kind of the shadow world into, the global financial market. And so during so following after the conference, I had the opportunity to meet with Treasury, including representatives of FinCEN, and we talked about some of our initiatives in this space. We brought up this issue of federal preemption, for example. The fact that, you have to be registered on the federal level, but then on the state level, you have to go to 50 different regulatory bodies in different states in the United States. And, some of these in some of the smaller states, barely know how to use a computer. And so to explain Bitcoin, piecemeal to one regulator after another is just, really is an insurmountable effort in some ways. So we brought that issue up to Treasury, and really their response was typical. I think they said, that the 50 the state federal system is just a fact of life in the United States, and that it's up to us as an industry to survive these barriers to entry. And another really interesting issue that came up in Treasury was that they kept on asking this question over and over again in various forms. And the question was, we thought Bitcoin was an outlier, and now we're seeing all these other virtual currencies coming up. Ripple, for example, why are these emerging payments coming out? Why is the existing system not sufficient? And so it kind of betrayed a fundamental misunderstanding about the incredible potential of Bitcoin, if not as a unit of exchange, as an electronic network that provides secure, instantaneous global transfer. And that was a point that actually did resonate with Treasury. And we, at that time, Patrick and I had talked about forming a broad industry coalition. So instead of each business trying to talk to regulators in a piecemeal fashion, to really form a cohesive group that could actually carry some weight and create some institutional changes on the state and federal level. So, Patrick and I have been talking about this coalition, and on our end in California, we've been, actually after the Bitcoin conference, we had people coming up to both of us, asking how they could join this effort. And it became very clear that, all of us are very interested in seeing this industry survive. So, on our end, we've been forming a self-regulatory organization. And we have the full blessing of Treasury. This is really a way for us to build a standards body that actually addresses the way our technology works and the real risks that are posed, rather than a reaction to perceived risks. So, we've made a lot of efforts on this front, and I'd be happy to share more details about that. But it is in the works. We're having a meeting of people who are interested in forming compliant, sophisticated businesses to join and make a public statement. In July, we have recruited some pretty heavy hitters to join the board as an independent board of directors, and we are looking to form some sort of standards by the end of the summer.
So regulators in the United States do not really have an integrated approach to the matter?
No.
And they still need to learn about this? They sort of shifted the burden of regulation to the industry, which has formed a self-regulatory body now. Is that a summary of the summary?
I would say so. And so often when I talk about the U.S. market, and since we're in London, we shouldn't just focus too much on the U.S. only, although it's a very important market and it has a long reach out into the world broadly. But I refer to the U.S. as a payment technology backwater, and it's mainly because of this issue. When you deal with the U.S., you're not dealing with one country, you're dealing with 49, right? The FinCEN and 48 states that all have Department of Financial Institutions, Department of Financial Services, their own parochial rules and laws and ways of enforcing their actions, whether it's cease and desist letters or 10-day letters or informal inquiries. There's a number of different mechanisms they use, but they do shift the burden back onto the industry to prove their innocence, rather than actually creating an evidentiary basis for action first. So that's something that you have to be wary of when you enter the U.S. market. And while that's not great for U.S. companies and it's not great for consumers in the U.S. who don't have necessarily access to fast, performant liquid exchanges because there are these huge barriers to entry. It is an opportunity globally for other countries to take a lead. And I think that there are a lot of other countries looking at this right now. If Stu can speak to Canada, but FINTRAC has said, they're blessing the idea of a Bitcoin exchange and not having these high barriers to entry. So I would look at it as anything, both a challenge and an opportunity as well. So since we're in London again, the challenge is to find those countries that are friendly, like Panama, maybe, and work there and maybe build inroads back into the U.S. if it comes to that.
Canada would, is that okay for summarizing the U.S.? Okay, because Canada would have been the next question that I would have asked to Stu. There was this amazing statement by FINTRAC saying that exchanges are not regulated. Go ahead, do what you want. Could you give us an idea of what the regulators in Canada, what their background is? Is it really as easygoing as it appears?
Yeah, lawyers don't like unequivocal answers, so yes and no. FINTRAC, since the San Jose conference, has made statements, not in the form of guidance, unfortunately, or even in the form of a presser, but there have been letters issued to several of the Bitcoin exchanges in Canada saying that FINTRAC takes the view that under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act in Canada, Bitcoin is not funds within the meaning of that statute. Accordingly, they will not be regulated as money services businesses when it's Bitcoin in, Canadian dollars out, or vice versa. So there are a few caveats to that. One is that other currencies, other foreign exchange, by that I mean other fiat money, non-Canadian fiat money like US dollars or euros, will be caught because those are funds. The other is that other laws are still going to apply. So while it may not be funds, Bitcoin is indubitably proceeds under the criminal code, and smart exchanges will do what they need to do to vet people under the money laundering provisions under the criminal code. I think maybe the most important caveat is that I think FINTRAC's going to change the rules. They're going to change the regs either sua sponte or in response to pressure from the FATF or its members. So I think there's a window. I don't know how big or long that window is going to be, but I think those are going to change, which might not be such a bad thing. I mean, in Canada, then you're still dealing with FINTRAC if they choose to regulate on those models, as well as one other province. The province of Quebec has a Money Services Business Act. So it might still be an attractive kind of place if FINTRAC does change the regs.
I promised you frustration. We're already into it. We have different legal approaches in the United States, and even the situation in Canada is not as pleasant as it looked in the media, where it just said, FINTRAC said exchanges are okay, is a little bit more complicated, I understand. And another point that we should work out is that most of these statements so far have been about Bitcoin exchanges. But of course, there's other players in the market. There's the users, there's miners, there's wallets, there's mixers. There's people who are dealing with derivatives, there's stock exchanges, there's funds. So, I mean, we could go through one after the other if we're very fast. Users, I think, is quite simple, not regulated anywhere. You can use Bitcoins. Patrick is twitching a little. You don't know, right?
I think that's a little bit up in the air based on FinCEN's guidance. Whether you're a user or an exchanger is, not always it's a fine distinction sometimes, and that's unfortunate, and that's a tweak that we can discuss.
Not too many legal details.
No, not too many legal details. I think there's like a quick fix to the guidance, and the quick fix is you just say, they say that if a user who changes Bitcoin to cash engaged in it as a business is an exchange, right? And therefore, they're a money service business. So the simple fix to the guidance to remove uncertainty about that is just to say, as a user, if you're going through an exchange, you're never an exchange. If you're going through a financial institution in exchange, you yourself are not an exchange. And this helps miners as well, and I'm jumping the gun on miners, but miners were called out specifically in that guidance, and it created a real ripple effect and a chilling effect amongst the miners, because now there's a worry about, well, just because I set up an ASIC rig in my basement, now I'm a financial institution? That's crazy. And it's obviously crazy, and it's just, they didn't get it, and that's okay, we'll fix it. But one way to do that is to just say, whenever you go through a regulated financial institution, you yourself are not an exchange. That's not such a big ask, right? And the other is to just set a de minimis level. If you're transacting less than 1,000 USD, whatever currency, a day, you're not engaged in the business of transacting in exchanging, right? And so you're not an MSP yourself. These are like little simple tweaks, and hopefully somebody from FinCEN is listening, right? And we can engage them and talk about that, and we'll have those conversations at Treasury as well. But
stock exchanges based on Bitcoins, another problem, I guess. There is some Ampex, there's Bitfund, they're doing business on the internet. I guess it's not regulated yet, but we can expect regulation because trading securities on the internet just like that does not really work. I guess the situation for derivatives is kind of like similar. Also, there's a great OTC market for derivatives in the traditional financial system. But I'm also aware that the EU is at the moment discussing, and I think in the US too, to regulate the derivatives OTC market. We have the funds. I know that there may be somebody in the audience from Switzerland who wanted to start a fund. I came across his blog the other day, and he talked to his lawyer, and the lawyer explained him what it means to set up a fund in Switzerland. And I don't know whether he's still going on with the project, but it's quite difficult. Also, one should say that this is not specifically a Bitcoin problem. This is a fund problem. Also with securities, not necessarily a specific Bitcoin problem, it's a securities problem.
Yes, anytime securities are sold, it raises an additional level of regulation that's really not central to Bitcoin. But I did want to comment on what Patrick said. There's nothing wrong with being a user of Bitcoin. There's no law in any country that I know of that prohibits the use of Bitcoin. Patrick's brought up a potential issue if you exchange Bitcoin into fiat currency. But as far as a user is concerned, there's no problem. In addition, if you're a merchant and you accept Bitcoin for goods or services, there's nothing prohibiting that either. So I just wanted to clarify that that on one end of the spectrum, there's sort of a safe harbor for users and merchants. And I think that's going to help the Bitcoin community flourish. As far as actually converting the currency, that creates a problem. But it's one that will be solved ultimately when there are licensed exchanges to deal with that. So in the States, we are in this money transmitter land only because there are no banks that have yet accepted Bitcoin. Once a bank accepts Bitcoin, that will apply across the whole country, and you don't have to worry about a state-by-state analysis. So this issue with exchanging is an issue we're dealing with now because we're a young industry, but it's one that's going to be solved.
So, and I would add that to reiterate Dan's point about being a user, I've personally never bought a Bitcoin and I've never sold a Bitcoin. I've only earned them and spent them, and that's it. And I'd like to spend more, so please, merchants, pick it up. And that you're absolutely correct. That is a safe harbor, as it were. You don't have to worry about any issues there.
So as a summary, we have the problem with exchanges, that it has been taken up by the regulators already. But those who want to do securities exchanges, trade derivatives, set up funds, they must be aware that there is regulation in the background. Maybe not specific Bitcoin regulation, but general regulation. And of course, setting up ATMs for Bitcoins is probably regulated too. There's an ATM machine in the other room. Be prepared to come within the scope of regulation as well with the ATM machines. I would say that sums up the situation in North America. So shall we move over to Europe then?
Yes, I just did want to make a comment on the minors. I know that some lawyers have interpreted the guidance to really put the minors in jeopardy. In my opinion, if you read that closely, I don't think the FinCEN is targeting the minors in any way. And when they talked about people creating currency, they were not talking about minors. They were talking about the original central administrator that issued the currency. So there's a little confusion there, but I don't think that there's any, at least I haven't seen any U.S. enforcement on minors yet.
Europe. Anybody want to take on Europe here? Great.
I will volunteer for this one. Payward is a global company, and so we have been in meetings with regulators all around the globe. And it's been hard work. It's been educating people, really one individual at a time, one regulatory body at a time. And what you're seeing is that because this is a young industry, because the laws are slow, and usually the ones that come out are pretty reactionary in terms of disruptive technologies like Bitcoin, you're really seeing these competing regulatory regimes and competing land grabs for jurisdiction. So you really see, we touched on this a little bit, but the reason why we're in money land in the United States is because, there are several buckets and labels that we can put to mediums of exchange. We could call it money. We can call it a commodity. We can call it a security. We can call it a payment instrument, a money order, a check. So there are all these different labels that we could put on Bitcoin. And the way the law works, unfortunately, is by analogy, which sometimes doesn't translate very well for things that don't analogize. So what you're really seeing is in the United States, they have carefully said that Bitcoin is not money. However, it belongs in the money bucket because it acts like money. So we're being treated and regulated. Bitcoin is being treated and regulated as money in the United States. In the EU, this is not the case. The UK FCA has come out and said that they don't consider Bitcoin money or e-money, and this is a view that is shared by the European Commission. And actually, a lot of times the European Central Bank, it's not exactly a trailblazer. They're known as being very conservative. And if you look at their virtual currency study, their white paper that came out in October of 2012, you can see that it's actually a pretty reasoned opinion. They say here are two case studies. You have a decentralized system, you have a centralized system, Linden dollars and Bitcoin. Here's the way it works. Here's how we see the current regulations bearing on these two different new forms of virtual currencies. And it's largely unregulated now. There are certain risks, and let's wait and see. And let's deal with the risks when we know what the risks are. So you see there's a little bit more of a reasoned approach in the EU. And, there was a SWIFT conference in Belgium just shortly following the Bitcoin conference. And at that conference, they had this huge 8-foot screen, I believe, where they showed the live transaction feeds of Bitcoin transactions. And, from what I recall of the article that I read, the United States is really 5 years behind the EU in payments innovations. So, you really can see that because this is because these are new regulatory regimes, like Patrick said, there's a lot of room right now to make some reasoned arguments about which regulatory framework it should fit in and what kind of rules should apply to a technology like Bitcoin. So really, this idea of getting out a consistent narrative that we can use with regulators to properly show them, where our businesses belong, how they should be regulated, how we are addressing consumer protection issues, privacy issues, financial fraud issues, AML, terrorist financing issues. These are all things that we can address, but we need to do that in a cohesive way, and we need to be able to present that to regulators in a way that they'll understand.
Yeah, and I would follow up on that. I think that's an excellent point. And I've talked a little bit about how, as a community, we need to come together and really think about what are the things about Bitcoin that we can maybe give a little, and where are the lines in the sand that we have to draw and fight for, right? So what are those things? Is financial privacy a line in this? To me, it is. It's a line in the sand that says that's something that's worth fighting for, right? Decentralization, that's something that's worth fighting for, right? And there's some other things that maybe we can give a little, like do exchanges have to run the 4 pillars of AML KYC? Yeah, we can give on that, right? There's going to be an intersection between traditional finance and this new economy. And at that point, yes, we can maybe give a little ground there. But some of the other elements, we need to come together and say, here's where we can give, here's where we fight. And I think that's really important.
Come together means that you're recommending that Europeans set up an organization similar to the Bitcoin Foundation in the US, self-regulatory maybe, to approach regulators as a community and not as single and rather small startup companies, and educate them about Bitcoins and also discuss how to deal with it?
Yeah, so actually it's a great point, and thanks for the softball. The Bitcoin Foundation is setting up local chapters right now all across the globe. So if you're in a country where there isn't a local chapter that's being set up right now and you're interested in helping to organize and run one, then please come talk to me, talk to John Matonis, who's heading up that initiative for us on the foundation. It's that kind of grassroots, from the bottom up approach to handling these issues, where we can come together and make a big impact, not just in the US, not just in the EU, everywhere. Argentina, the Netherlands, the UK. That's how we need to approach this issue. But again, having these conversations about, what are we willing to fight for and what are we willing to give on, that's a very important first step in all of that.
Okay, I hope this was heard by the audience. Assuming that the majority of the audience is from Europe, I think I should make some remarks about the regulatory situation in Europe. As Constance already mentioned, there's the analysis by the ECB. What you must have in your mind when thinking about Bitcoins in a legal context in Europe is always e-money and the Payment Service Directive. Directive means it's a law on the EU level which needs to be transformed into national laws, which has been done in most of the EU countries. The ECB analyzed Bitcoins and came to the conclusion it is not e-money, and therefore the Payment Service Directive is not applicable. That means, as a result, it's basically unregulated at the moment. Then I'm very grateful to the Bitcoin magazine, because last week they published a summary of regulatory comments of the last year, and they also published them September last year, covering the month before. And summarizing these summaries, there's not a lot of statements in Europe about Bitcoins. The regulatory authority in Norway gave a short explanation of how it works and says it's outside of the control of governments and it's risky. Okay. There was a Finnish politician on TV who was asked by the moderator whether Bitcoins are illegal, and he said no. Doesn't get us anywhere either. There's a lot of statements by various organizations which are involved in the security area, and they always come back to AML, anti-money laundering. This is another issue that you must have in mind. I understand that regulation in the US was to a large extent about anti-money laundering as well, and this will happen in Europe, I'm quite sure, because anti-money laundering has to do with organized crime. It has to do with terrorism finance. It means know your customers. It means keeping records of the transactions, and it means reporting to certain authorities.
And, sorry, pardon the interruption, but just to follow, just because there hasn't been any official statements or public statements, at least from the regulatory bodies in the EU. On the institutional level, we're dealing with AML and KYC requirements of financial institutions for institutions that we bank with abroad. So, on that banking level, the banks are going to require any business that signs up for a merchant account to have KYC and AML policies in place for the clients they onboard, because they ultimately become clients of the bank. So, we have the institutional level that also needs education, that also needs to understand the policies that we're putting into place that make them feel comfortable with us as a part of the financial market. And then we have, the regulatory issues. So, those things, work in tandem, but separately.
So, and it's interesting you bring that point up, because I often make the point that you can make your best friends over common enemies, right? And so while we, talk about the banks and everything, one thing that would really help both the banks out and the Bitcoin companies out would be some sort of safe harbor provisions, right? That say, if you follow the 4 pillars of AML KYC and you do it in good faith, there is no criminal liability, upstream or downstream, right? So if the banks could have confidence that they can bring an exchange online, and one bad customer on that exchange doesn't open them up to huge civil fines and criminal liability, that would just ease all this chilling effect that's happening right now through the banking industry. So, working with banks, working with these institutional players, educating them, yes, but also finding common ground where we can both work together to solve common problems. I think that's a very, very important approach.
And, this is not a new concept in technology law. You have the DMCA, the Digital Millennium Copyright Act, and, that was kind of a response to the fact that the laws couldn't address what the technology did and couldn't address user behavior, which was modeled on what could be done. So, you had these safe harbor provisions that came out as a way of shielding, online service providers that merely provided a platform on which users could conduct their business, entertain themselves on the internet, which is essentially a free system. So really it allowed, businesses like YouTube to survive, and that we really need those sorts of reasonable policies applied in the Bitcoin context, which is kind of why we've really been working hard on having this self-regulatory organization, so it becomes a body by which we can propose safe harbor rules, we can propose de minimis amounts, we can give Washington and give regulators around the globe the kind of safety and comfort that they really need to be able to embrace this kind of technology.
I'll pick up the thread. One more point on that. I agree wholeheartedly with Patrick's comment about not making AML a line in the sand. Coming from the gaming sector, I know for a fact that you can, and there's been a lot of gnashing of teeth about how AML CTF requirements can be fulfilled in a Bitcoin environment. And I know for a fact in the gaming space, in the online gaming space, that you can, with a little bit of thought and some effort, stepping back and looking at your AML CTF requirements as a whole, you can accommodate Bitcoin within that environment. It's not to say that Bitcoin itself can be regulated, because I don't think it can, but actors in that space that are conforming to their AML CTF rules and policies and procedures set down by the regulators, they can accommodate a Bitcoin denominations within that framework.
Thanks, Stuart. Before we leave Europe and take a quick look at some other jurisdictions, I want to get back to one more statement from a European regulatory body, which is the German Regulatory Authority. The German abbreviation is BaFin. And here I have to criticize Bitcoin Magazine because your summary doesn't hold. And if you read German and if you're a lawyer, and you are aware that this statement was very carefully drafted. The wording is very subtle. So what BaFin is saying, first, they analyzed the e-money regulation that the ECB also analyzed, and they come to the same conclusion that Bitcoins are no e-money. Then the next step is they refer to Bitcoins as unit of value. I go a little bit deeper into this because really I regard it as a very significant statement that at least the European players should be aware of, and it's quite explosive as well. So they refer to Bitcoins as units of values, that is not units of accounts. Units of accounts is a technical term. Units of value doesn't mean anything, but contrary to the ECB, which more or less said, all right, Payment Service Directive is not applicable, the BaFin, the German authority, as I say, very carefully drafted, says, insofar, however, only the creation of such units in value and their use as medium of payment are free. Means that other uses of Bitcoins may be regulated. And in the next sentence, BaFin opens the back door and says, if, however, such units of value, Bitcoins themselves, become an object of trade, that is, if Bitcoins are traded themselves. Don't ask me what that really means. I don't know. I'm a lawyer. And BaFin kept it vague. They want to keep it vague. But they say, if Bitcoins are used as an object of trade, such transactions, in accordance with their structure, it's another backdoor, maybe banking transaction or financial service transactions. What BaFin does on a more abstract level is they want to look at the structure of the transaction that you are doing, and then they decide this may be a banking transaction or this may be financial services, which would bring the entire shebang of financial regulation in Europe down on you. All right, confusion on a higher level. All I'm saying is BaFin is a very powerful authority in Europe. Germany and the UK, I would say, are the most powerful regulatory bodies in Europe. And BaFin took a very close look at it, and they're thinking very hard about what they should do. And they thinking about banking regulation and financial service regulation, which would make Bitcoin operations in Europe very costly, very complicated. But it depends on the structure of the transaction. And now back to what the other panelists say. There is an opportunity to go to BaFin and to talk to BaFin, not as a single company. If a small startup company wants to set up an appointment with BaFin, maybe you get the appointment, maybe you can talk to these guys, but you're not really in a position to discuss Bitcoin operations with regard to banking regulation, financial service regulation on a European level with an authority like that. And if BaFin, which I'm certain they are doing already, they're discussing this on a European level, which means Brussels is somehow involved in the background already. There is things in the making. Okay, now let's leave Europe, because there's constantly the question which could be other interesting jurisdiction for Bitcoin operations. I call this competitive regulation, and ask the question to the panel.
My understanding is that Austrac, they have more specific rules down there, and they have actually concluded that Bitcoin does not fall within their definition of, I think it's e-currency, or they have a law in the books actually specifically addressing this a few years ago. So maybe somewhat like Canada, to the extent that Austrac, which is their FIU, is taking a bit of a hands-off approach, but I would expect several of the same caveats to apply. Look at other laws, potential securities, FI rules, that kind of thing. And that might be narrowly tailored to just Australian dollar, Bitcoin transactions, and vice versa.
So I think that when you analyze this issue, you're going to have to do it on a case-by-case basis, basically depending on what your business model is, your funds flow, things like that. There are many businesses, by the way, we've talked a lot about these financial regulations. There are many, many businesses to be built that will never touch these, right? And I often talk about the 3 waves of innovation in Bitcoin that have happened so far. There's the first wave, the pioneers, many of whom took arrows and some of whom have survived. And then there's the second wave, and we're seeing that play out now, which is the infrastructure plays, the mining, the storage, wallets, merchant payment processors, and the exchanges, of course. And that is red ocean, right? There's not a lot of opportunity left in that space. And where there is, it's maybe not even the most attractive place to be because of all the regulatory hurdles and the hoops you have to jump through. It's in the Wave 3 space that if you're an entrepreneur right now sitting on the sidelines and you want to get into the space, the Wave 3 is imagine a world where all of those infrastructure plays are built. There is a fast-performing exchange and merchant services work. What kind of consumer services or business-to-business services would you build on top of this network? Those are the plays right now that make a lot of sense. Those are very fundable opportunities at this moment. And there are a lot of seasoned entrepreneurs looking at just those types of plays that are coming into the space. And it's those things that are going to cross the chasm for us to mass adoption. And once we have mass adoption of 50 million users, it's a totally different conversation that you have with regulators, right? When you have a $1 billion market cap and a user base in the hundreds of thousands, maybe a little more, it's a totally different conversation. And I'm frankly heartened at the level of discourse that I've been able to have and Constance has been able to have with the regulators. Usually they would just totally ignore this or just create rules on their own. But they've been very responsive. But when you're looking at a jurisdiction, understand your business model first, and then just walk through a matrix. What's the regulatory environment? What's the tax climate for your business, right? What's the brand equity of being in a certain location, right? Is Singapore a good thing or a bad thing? And what markets are you targeting? Are you targeting the U.S. market or are you ignoring it? And where are you going to have offices, right? And where's your headquarters going to be? Where's your team? So if you walk through those 5 points, you can usually come to a good determination of what is a favorable jurisdiction for you.
And again, in a lot of these smaller countries, you deal with regulatory bodies that are less sophisticated and perhaps don't have as much familiarity with Bitcoin. So it's both an opportunity and a barrier, which is one, you can make your case, or two, they can reject Bitcoin as a viable business. So you really have that opportunity to have that conversation in some of these smaller countries. Now, it's not going to help you in the U.S. In the U.S., if you serve any U.S. customers, it doesn't matter where you are. And so the U.S. market remains very restricted and very closed to people who are compliant. I can tell you, in Treasury's defense, they have said that they're not opposed to innovation. Of course, you can take that. They said they're not opposed to innovation, but it's really up to us as an industry to survive the current regulations, and that there are no special rules that are going to be made until we're relevant enough to make special rules for. So that's where building that ecosystem and building coalitions, joining the SRO, joining the Bitcoin Foundation chapters, that's where we'll be able to have stronger clout and stronger voice and be able to have, to be able to convince regulators on our own industry level how we should be treated, what categories apply, and what kind of policies we really need to have in place.
That's absolutely right. And you asked, do I believe him? And the answer is yes, I do believe FinCEN. I've met the director. I've looked her in the eyes. And her reputation stands, in my opinion. She's a straight shooter. But she's also a tenacious bulldog. If you're in her sight, she's going to come get you because she's a prosecutor. So you have to balance those two things. And I think that so when you have the director of FinCEN saying that I'm not targeting a particular industry, I think that's absolutely correct. But as a prosecutor, if she steps on a few people along the way to get her target, then that might happen. So you just have to be cognizant of these things. Lesson being stay out of the crosshairs.
Okay, before we move on to the question and answer session, I got to make a little advertisement for Switzerland as well. Because the term self-regulatory already came up in the discussion a couple of times. And if you go to the webpage of the Swiss regulatory body, FINMA, and you click on regulation, there's a pull-down menu which says banking regulation, insurance regulation, etc., pp. And then it says self-regulation, because self-regulation is an integral part of the Swiss regulatory system. You can set up an organization that sets up standards like best practice. You can discuss this with the Swiss Financial Authority, and they accept it. And in addition, Switzerland is a traditional land of banking, and it's one of the countries on this planet which fought the hardest for banking privacy, in particular against the US, as we all know, right?
Right.
Okay, anything to add from you guys here on the panel, or should we move to Daniel?
Just as a final note, and we touched on it, and Stu is sort of an expert in this area, is that with all these Bitcoin transactions, wherever you're operating, there are tax issues associated with it. So that's one thing to keep in mind.
Yeah, but that's a good point. Think international. You can be in London these days. You can have a company in Hong Kong. You can have your service in Russia if you really want to. And you can transact globally. Think international. The internet is boundless.
But to Patrick's point on the tax side, that's a very fluid. This whole matrix concept is very useful, but it's always fluid and fact specific. So one business model might have a completely different makeup in that matrix than another, and tax may be at the top of the list, or it may be almost an afterthought. So,
Okay.
Yeah, and I would say that just in general, okay, one last comment, right? I think we talk a lot when we talk about regulation about the law enforcement side of things, and we haven't touched on the consumer issues at all. And law enforcement is right now driving this issue, and responding to law enforcement in a proactive way is very important. We have to make sure we're not letting the tail wag the dog a bit, right? There are other agencies and there are other people in government who want to have a say in this. And sometimes they don't always appreciate the law enforcement side taking the lead on these conversations, right? I mean, at no point have I heard anybody in law enforcement talk about the fact that Bitcoin puts financial privacy back in the hands of consumers, right? And that's a really important point. When you talk to the FTC in the US and consumer protection agencies elsewhere, financial privacy and privacy in general is a big, big issue for people. And I don't know that they would appreciate one agency stripping that out of this system. So we can work with our friends. I know that we've been talking to the Senate Committee on Homeland Security and Government Affairs. Gavin and I went into the DC Death March, and I really appreciate Gavin doing that, and I think I owe him many, many beers for having to endure it. But they're looking right now at a holistic approach from top of government down. What agencies should be involved and how should that pie be divided up? So we don't have to necessarily accept right now what looks like law enforcement driving this process. And again, having things like Constance is talking about, being engaged in those conversations is really important. So let's embrace that and be thankful that there are people in government who want to not just demonize this technology.